In November 2014, President Obama announced an executive action, Deferred Action for Parents of Americans and Lawful Permanent Residents, or DAPA for short.
Tonight I'd like to talk with you about immigration.
DAPA is a deferred action policy. Effectively what it does is the president tells a significant number of aliens, we are not going to prioritize removal. We're going to put you at the bottom of the line. And as a consequence of this, the government grants what's known as lawful presence. And by granting lawful presence, these aliens effectively get work authorization, eligibility for Social Security, eligibility for Medicaid, and a host of other benefits. DAPA would also have the effect of granting up to 4.5 million aliens who are not here legally with this lawful presence. Texas and 26 other states challenged DAPA in court, asserting that it violated provisions of administrative law and the president's duty to take care that the laws be faithfully executed. The district court agreed and granted a preliminary injunction halting DAPA. The Fifth Circuit Court of Appeals affirmed, and now the case is before the United States Supreme Court. There are three major disputes in United States versus Texas. The first is the issue of standing. Does Texas and the 26 other states have the ability to challenge DAPA in federal court? That is, were each of these states injured by this executive action that will provide them with Article III standing? For many years, Texas has had a statute that says if a person has a lawful presence, they're eligible for a driver's license. As a consequence of DAPA, many new aliens will gain this lawful presence and be eligible for a driver's license. As a result, there's an increased cost that Texas must shoulder. This is an injury they asserted. The second issue concerns administrative law. DAPA was not announced through the notice and comment rulemaking process. It was simply announced in a PDF posted online.
There are actions I have the legal authority to take as president.
Texas and the other states have first challenged that this is not a proper method for announcing this policy, that it would need to go through the notice and comment process. The third issue is perhaps the most unprecedented. The Supreme Court has asked for a briefing on whether the president has violated his duty to take care that the laws be faithfully executed. Texas has challenged that the DAPA program amounts to a suspension of the law, and this is in fact a way to bypass the laws of Congress. So Texas will argue to the court that the president is not only violating the statute, but also engaging in lawmaking and violating the Take Care Clause. The federal government's best argument in this case concerns prosecutorial discretion. It's uncontroverted that the government only has enough money to deport roughly 400,000 people per year. The number of people here subject to deportation is far greater than that. So there's really no dispute that the government must prioritize some people over others. So what the government will argue to the court is this is merely a routine exercise of prosecutorial discretion, and the government has decided that certain aliens with families who have not committed crimes are less of a priority, and they go to the bottom of the list of who gets removed.